Morning, everyone, and welcome to our latest webinar, which is an inheritance tax planning update from a tax and legal perspective. I'm joined by my partner, Michaela, and Aarti from our friends at Wellers, and I'll be asking them extremely difficult questions about inheritance tax very shortly. So my name is Mark Rubinson. I'm a partner here at Gravita. I've been a partner for a long, long time, and I specialise in SMEs and tax as well. A bit about Gravita: we are a full-service top 30 firm of chartered accountants. There's over 400 people here, and we help both individuals and SMEs expand through tax, accountancy, audit, outsourcing, and advisory services, both here and through our cousins around the planet through our DFK partnership. 40 partners, 400 team members. We're in London, Oxford, Essex, Bristol, and Exeter. We deliver innovative and practical solutions to our clients. We look after multinationals, high net worths, entrepreneurs in lots of sectors, including property, technology, financial services, professional services, and more. Thanks for joining us. I think we've got about 350 people this morning, which is a record for us. Webinars are very popular. Please look at the events page on the Gravita website and you'll see lots more. You can put questions on the chat, and if we've got time, we'll go through them afterwards. Or you can drop us a line and we'll deal with your queries after the webinar. There'll be contact details you'll be able to see.
Hi, my name is Michaela. I am one of the private client tax partners here at Gravita. I'm based in London. I specialise in inheritance tax, estate and trust planning, issues, which is a slightly unusual one, property, and what used to be residency and domicile issues, which are much more exciting these days. I've about 20 years in the tax industry. I just like helping people.
Good morning. Thank you for joining us today. I'm a senior private client solicitor at Wellers, and I specialise in probate, wills, trusts, and court protection work. Wellers is a full-service law firm with offices across London, Kent, and Surrey, and we have specialist expertise in many areas of law, including private client, family, residential, commercial, and litigation. Hopefully today we'll give you a beneficial discussion, breaking down some of the legal jargon to enable you to put strategies in place for the future.
Lovely, thank you. Okay, so we'll kick off the first question. Can I write my own will or use artificial intelligence to do it for me?
So that's a big question. As a private client lawyer, I would always recommend that you don't do that. In order for your will to be legally valid, it needs to comply with Section 9 of the Wills Act. Section 9 says that it needs to be in writing, signed by the person making the will, and signed in the presence of two independent witnesses who also must sign, and you all must be present together when signing. So that's the legal basis for validity. There are risks involved if you were to do it yourself or use AI, because you may not comply with Section 9 of the Wills Act. If it's deemed that your will is invalid, you could then have an intestacy or partial intestacy, which would mean that your estate is distributed under the law and not necessarily to the people that you want it to go to. The law will dictate who inherits under an order of priority of family members. Also, if you do it yourself or use AI, you necessarily wouldn't take into account your specific financial circumstances. You may actually end up paying more inheritance tax than you need to if your will's not structured in the correct way, taking into account a complete picture of your finances at the time. You may not be able to use the inheritance tax allowances to the maximum that you could do if you got advice for it. Also, family dynamics. You know, everybody, or not everybody, but quite often people are on second marriages or have children from a previous relationship. You may want a trust in place if you want your children from your previous relationship to inherit, as well as a new spouse or new partner. And so you may want to include an interest in possession trust, which we also call a life interest trust, which would give your new partner or spouse a right to occupy your main residence for their lifetime. And then on their death, the property would go to your children. And so that way, both your children and your new partner or spouse would inherit from your estate. If you're cohabiting and you're not married, or you've got a partner and you're not married, unfortunately the law does discriminate against unmarried couples at the moment, so you don't get the same allowances as you would if you were married. You should take advice, because there are certain things you could do to maximise the allowances available to you from a tax perspective. Also, if you've got assets in another jurisdiction, so if you've got foreign assets, important that you prepare a parallel will so that the assets are covered in that jurisdiction. Take advice on what happens on your death in that jurisdiction, because there are certain laws in certain countries that may take precedence. So in Italy and France there are succession laws, for example. Would definitely recommend that you take advice when you're preparing your will, so that all factors can be considered.
Thank you. Next, can I give my home away to my children in order to avoid inheritance tax but still live in it?
This is probably the most common question we get. Everybody thinks that they can do it. Everybody's been told, well, it's in my kid's name, I don't own it anymore, no inheritance tax. Unfortunately, HMRC are one step ahead of us, and of course they know people want to do this. So in a very short answer is no. Now, it doesn't mean you can't do it. It's just that from an inheritance tax point of view, it may not necessarily work. It won't work unless other things are done as well. So one of the issues is, of course, if you want to give away your primary residence, there isn't any capital gains tax to pay, which is why it's a very attractive asset to try to give away. But from an inheritance tax point of view, if you're going to continue to live there, it's a gift with reservation of benefit. Now, when there's a gift with reservation of benefit, HMRC effectively ignore the gift. So it's still included in your estate on death, whether or not you live the 7 years or not. So I think most people are familiar with the 7-year rule, but we'll touch on it a bit later. On top of that, you've got all the downside with capital gains tax, because if you decide to sell it later, because it's not your property for capital gains tax purposes, assuming your kids are not going to live there with you, they will not get a relief when they sell it. So you could end up with not only a capital gains tax liability if you decide to move later, but for inheritance tax purposes, it just hasn't worked.
And there's a conveyancing issue as well.
So when you are gifting, if you did want to gift your property, you would need to deal with the legal formalities, which would be preparing a transfer deed that would be registered with the land registry. We would also recommend that a deed of gift is prepared, which solidifies your intention that this is a genuine gift and will show that your ownership rights have ceased to that property from the date of the transfer.
Okay, lovely. And if I paid rent, does that help?
That does help. And in some circumstances, that can be the answer if you're prepared to pay rent. Depending on how much income your children have got, to pay them rent, for them to pay income tax on it, could mean you're getting money out of your estate, so you're not paying 40% on it. And if they're a basic rate taxpayer, that can be a good strategy. But the rent needs to be revalued to full market rent every 5 years, and then the income is taxable on the individuals. And if they're higher rate taxpayers, you're not really achieving a lot. But that would help from an inheritance tax point of view.
I guess you need to crunch the numbers,
Absolutely.
the tax
Absolutely.
paid and the rent.
Every case is different, unfortunately, on these. And again, there's a legal aspect to that about making sure you're getting the rental agreements.
Right. You should always have a rental agreement in place, which would show each party's legal obligations and responsibilities regarding, the payment of rent and maintenance of the property, and also would need to include a clause regarding regular rent reviews, because you need to show that it's not a gift with reservation of benefit. And so regular rent review clause would be imperative in the agreement, and the agreement could then be produced as evidence to HMRC to show that it's not a gift with reservation of benefit.
One of the other aspects is to make sure that you are paying your way as well, covering all of the expenses yourself. That could be seen as a benefit. For example, if you give your kids the property and they are covering expenses for you to make up for the fact you've given it away, then again, that is a reservation of benefit.
So I've given my home away, I still want to live in it, and the children want to live there with me.
Okay, that is quite helpful if you wanted to give a share of the property away to the kids. So, for example, if you are living there as a couple and you've got a couple of kids who are going to live with you as well, and you all had a quarter each, that arrangement can work under specific circumstances. It's not a reservation of benefit if you're all living there, if you've all got equal shares. So you need to retain a share to make it look less aggressive. You've got to make sure you're all covering your own costs. The point is at the point where your kids decide they want to move out or they want to get married and move somebody else in. the family dynamics change, everything changes. You do have to re-review everything because you could trigger the gift reservation of benefit rules if somebody were to move out, for example.
If you do that, though, you should have an occupation agreement in place, which shows that you both all have equal rights to occupy the property and not one party has an exclusive right of occupation, so that you can ultimately show that you're not receiving more of a benefit from occupying the property than your children are, and that it is equal.
I've got the family home, but I've got other properties that I'm not living in, rental properties, those away. And does that work for inheritance tax planning? And here's a bit of a kicker. I still want to keep the rent coming from the rental properties, and I still like to use the flat in my back. So
You
what do I
really do
do?
want your cake and eat it, don't you, Mum?
Absolutely.
Okay, let's break it down a little bit. Firstly, when you make the gift, if it's not your main home, you've got a capital gains tax liability to think about. So if the property has grown in value during the time that you've owned it, there will be some capital gains tax. It's currently 24%. That's a dry tax charge because clearly there's no proceeds to pay this tax. So I'm sorry, you're going to have to go remortgage your other properties, one of your many other properties, in order to pay the capital gains tax on that one. And then you've got to have a think about, okay, so the kids now own this, you want to use it. So we go back to you want the rent from it, for example. If you've given away the whole of the property, that's never going to happen. That's just not viable because, again, that falls in the gift of reservation of benefit rules. There are particular circumstances where if you were to give away a share of the property, you would be able to keep your share of the income and potentially more. There are ways of structuring that. If it's for a holiday home, though, for example, and you want to live in it, again, if you wanted to live in it a couple of weeks or use it a couple of weeks a year, that's not going to be a problem. So there are restrictions on that. But if it's only a couple of weeks a year, or you're always going to use it with the kids, that's viable. But if it's somewhere where the kids are really not interested and you're just going to keep using it, that's going to be a gift of reservation of benefit, but you can pay rent.
And then on the rental properties, the percentage to give away, is there a percentage you'd recommend?
Well, I think if you were going to do that, I would probably not give more than 50% away. I think it's a bit on the aggressive side to try and do more than that. If you equal ownership, how do you feel about that? Is there an optimum amount you should keep from a legal perspective?
I suppose not. It just depends on your financial situation and potential tax implications for yourself.
Yeah, of course.
Also income tax.
And SDLT.
Just want to clarify, Michaela, you give away on the rental properties 50%.
Yeah.
Does that mean the rents split 50-50 or do the rents go in a different proportion?
It is possible under some circumstances to arrange it so you can retain more than 50% of the rent.
Right.
There are particular bits in the law that allow you to do that if you're not occupying the property. It is slightly aggressive, but it can be done.
You can put the properties into a property investment company because there could be potential income tax advantages for that.
Absolutely.
You'd be paying corporation tax rather than income tax personally, so the rate would be lower. At the moment, it's 19% for corporation tax, but there are also quite a lot of costs involved with transferring the property from your personal name into the company, SDLT, capital gains tax. Yeah. It may be more beneficial if somebody wanted to manage and grow a larger property portfolio, maybe as a full-time occupation into retirement.
Incorporating your property portfolio is a massive subject, something you could probably do a whole webinar on. Definitely another avenue to explore.
Lovely. Moving on now to changes in the recent budget. The pronouncements have been made regarding both business property relief and agricultural property relief. We've all seen Jeremy Clarkson driving his tractor up to Whitehall, or has been driving it. And that's going to be, both of those are going to be restricted from April 2026, which is now less than a year away. Is it better to start giving away qualifying assets, farms and businesses now, or should one sit tight?
It's a very difficult thing to think about at the moment because we know that consultation on this only finished last week, so we don't have the final legislation. We're all hoping that there may be some changes to the legislation. As it stands, it's going to be a very individual thing to look at. If you want to start giving things away, either directly or via a trust, you've got a lot of things to think about. For example, if you want to give your business away and giving away shares, can you afford to give up the income? Is there going to be any capital gains tax to pay? Now, in the case of most things which would have qualified for BPR and APR, you can defer the capital gains on that, but that loses you the potential uplift of capital gains tax on death, because usually when somebody passes away, inheritance tax is payable, but not capital gains tax, and you get this automatic uplift. And that can be very valuable. Losing that by making a gift and a deferral now can be quite expensive. On top of that, you've still got the potentially exempt transfer 7-year rule. If you give it away today and pass away within 7 years, there's still a risk of some inheritance tax being payable. That will be at the rates that apply when you pass away. Something that would have been BPRable would have got 100% relief. If you die within 7 years, you're still going to have only 50% relief. So there's still taxes to think about there. There's a lot of planning you can consider about getting an asset that currently qualifies into trust before April 2026, because there are still exemptions. Long term, you've still got to think about what we expect to be a 3% charge every 10 years. So there's lots and lots of moving parts to it. And each individual family has to look at it on the specifics. Is it going to be a problem? Is it not going to be a problem? And are you prepared to take the risk of not knowing what the final legislation is going to look like? And that's a problem, isn't it? How long do they take to release legislation?
They're going to maybe see where the chips fall and
I think right.
Potential to change. Yeah.
So planning issues, you want to skip a generation and give your farm or your business to your young grandchildren. Let's assume for the moment they're under 18. What do you do? How do you do it?
Okay, from a tax point of view, it's a great idea, because you're skipping a generation is always going to be a good idea. As long as it's a grandparent doing it, you haven't got the problem. If you give away to your minor children, if there's an income that continues to arise on it until they're 18, the parent is taxable on it. That doesn't work with grandchildren. But the issue you've got, of course, is asset protection. Are you prepared to give away those assets and that income to the kids? Their parents can hold it on bare trust for them until they're 18, but after that, that's theirs. I mean, you don't know what these kids are going to be like. So that's the risk. That's the reason we tend to use trust. Discretionary trust for this kind of thing tends to be the way forward. But that comes with legal costs and legal implications, doesn't it?
Yeah. Also, something else that may be important here is that minors can actually be shareholders.
Oh, yes.
So under the law, there's no statutory provision that actually prevents minors from becoming shareholders. You would just need to check the Articles of Association to make sure there aren't any restrictions there. You would either issue them existing shares in the company or create a new class of shares with different rights. That may be important for you because as parents or the adult shareholders, you would want to have more control over decision making in the company. So you could create a new class of share for the minor shareholders with non-voting rights. It would give you more control over decision making. So yeah, minors can't. I mean, the good thing to note is that minors can't be directors until they're 16 years old. So you would still have day-to-day, management of the company.
And just to square the circle on that, you've got 10-year-olds, 12-year-olds as a shareholder in the company with their colouring in books at the annual general meeting. Would you strongly suggest they have their own bank accounts to receive dividends if dividends are paid out?
You would want the parents having it under their trust somewhere. So
it would go into trust.
It would,
and that wouldn't be an issue from a tax perspective. Dividends didn't go into the 12-year-old's bank account.
No, because it would be on trust. It would be there. So I wouldn't be concerned about that. But Aarti raises some good points about family investment companies, to what we're kind of looking at when you're looking at different classes of shares. And that's something we've done a lot of work on here. If you're interested in that, there is a video on our website. We'll send details around about that later. And hopefully I'm going to try and persuade people here to let us do a webinar on that later in the year, because it's a really interesting topic and it's becoming more and more popular, even more popular than trust. I'm still a big fan of trust, but trust in combination with a family investment company is probably the way a lot of people are thinking of the changes that are going ahead.
We have quite a few inquiries about family investment companies. So it's definitely something people are thinking about.
So if I put my assets into a trust, will that stop my family from paying inheritance tax on those assets when I die?
It depends. It depends on the assets, depends what's going on. So if you don't want to use those assets, the important thing is you don't need to have access to those assets or you put it into trust. If you do, we've got settler interested trust, and that's a problem from an inheritance tax point of view because largely the gift is ignored. Now, if you want to pop something into trust, say rental properties, for example, you can defer the capital gains tax, which is good. And as long as you survive for 7 years after it's been done, then it falls outside of your estate for inheritance tax purposes. Presumably you're going to use a discretionary trust because they give you the most flexibility, but they then fall under the relevant property regime, which means that every 10 years, the trust is going to pay a charge on the value that's sitting within it that falls above the nil rate band. Now, the nil rate band is £325,000, thankfully, per settler at the moment. So between a couple, you could 650 into a trust So there's no charge going in on that. If you go above a 650 on the way in, you've got a 20% charge. And then every 10 years, you've got a 6% charge and the excess value. So while they wouldn't necessarily pay inheritance tax on your death as long as you survive the period for 7 years, it doesn't mean it's completely IHT exempt going forward.
Income's being accumulated.
The trust is going to pay tax at 45% on that.
Which is not great.
Which is not great, but if you've got minor beneficiaries and you can repay it out to them fairly regularly, they can claim the difference back. So if you've got a basic rate taxpayer who's paying tax at 20%, they can claim the excess 25% back on the income tax. If you've got a child, for example, who's got no other income and you can use up their personal allowance for the year, the whole of the 45% tax paid by the trust, they can claim that back. So there are benefits to it if you've got the right people. It doesn't help if you want to continue to benefit from the income or the asset, or your spouse does, or your minor children do.
Okay.
That doesn't work.
The costs are to running the
Trust, although they can be a good tool, it's important to look at the big picture when you are thinking about trust, because it's not just potential tax implications. There are also administration costs with running a trust, particularly if you've got professional trustees acting. There would be charges for that, although you would have peace of mind if you do have professional trustees, because then you know that your trust is being managed in the correct way, because they would most likely be regulated. And then you have accountancy fees, because you have to prepare annual trust accounts as well as account to HMRC for any income received by the trust in the tax year. So tax returns will need to be done yearly, and you need to register the trust. If the trust asset is a property, then you have also got potential property management fees, costs of insuring the property, maintenance. There are quite a lot of costs involved in the actual running of the trust. If it is a discretionary trust, there could be more costs because you have to value the assets every 10 years. If there are multiple beneficiaries, you may be making several distributions out of capital, and you may need legal advice for that. So there could be potential legal fees involved.
But that's not to put anyone off. Trusts are still a very good tool to be used, and in the right circumstances, they are a great vehicle. They are a great vehicle. I'm a big fan.
And what about for my home? Is that a good idea?
You want to live in it still?
I think so.
Yeah, you think so. It's not going to work. I mean, they're called a probate protection trust. They exist, but they do not work for tax. They can work, for example, you may not need to get probate on your property if it's in a trust when you pass away, and that can save some hassle. But effectively, it's still going to be taxable on your estate because you're still living there. It's a settler interested trust. I don't think there's nothing clever we can do with it, really, is there?
No, I mean, the only thing is, as I mentioned previously when I was talking about wills, is on death, you could have an interest in possession trust, which you could put your main residence in for, life tenant who would be your partner or spouse, and then on to your children. That would be a tax effective way of putting your main residence into trust. But again, it occurs on death
during your lifetime.
Putting assets into trust to protect my kids if they get divorced.
It can work, but the court would ultimately look at trust assets last and use other assets to offset first. They wouldn't necessarily want to break up a trust in the first instance. And they would need to look at whether there is a realistic prospect of you actually benefiting from the trust assets, who are in control of the trust assets. So, for example, if the parents have put assets into trust for their daughter or their children and one of them's getting divorced, it's probably unlikely the court would consider using this in any financial arrangement because the daughter herself is not in control of the asset and there are also multiple beneficiaries. How likely is it that she would actually benefit from the whole of the asset in trust? Whereas if the daughter herself had put assets into trust for the benefit of her children, she's obviously getting divorced now, the court may look at breaking up that trust as a last resort because she is in control of that asset. She would need to show that it's a genuine trust, so to speak, and she hasn't actually put the property into trust just so that her husband doesn't get a share.
Back in 2015, 10 years ago, George Osborne decided that pensions weren't going to be full part of your estate for IHT purposes. Rachel Reeves has now reversed that. So what should we be doing to avoid inheritance tax being paid on estates?
This is another tricky one because the rules don't kick in until April 2027. So will they change? Probably not, but it does give us time to plan. You've got a couple of years to think about planning. If you've got an untouched pension pot and you pass away after the age of 75, when your beneficiaries draw on that, there is income tax as well. So the tax rate is enormous, 60%, very higher than that. It's very high. It's an efficient way of dealing with it. I guess if you've not taken the 25% out tax-free, then taking that if you don't need it and giving it away, that's always going to be the idea, because if you can survive the 7 years, at least that bit you haven't got inheritance tax on. Another strategy, of course, is to draw the income, pay the income tax on it, and then give the income away. Now, potentially, you may still be paying 40 or 45% on it, but at least you're avoiding your kids from paying additional income tax on it later. If it's a gift out of income, and it's a regular gift out of income, you haven't got additional inheritance tax on it. So that can limit how much tax is payable on it. But it's unfortunately, it's a bit of a sticky problem. It's a sticky problem.
I think it's another crunching the numbers, isn't it?
It is. It's a crunching the numbers. You could also looking at trust again.
Yeah, so you could take the pension out and put it into a separate trust. That could give you more control over the funds, maybe give you wider investment options for the funds. To look at the tax and also potential. I mean, it would need to probably go into a flexible trust or a discretionary trust. You'd need to look at the tax implications of actually pushing it into trust, because there could be an immediate charge to inheritance, turning it into trust.
And a 20% charge on top of the income tax charge, you've probably not saved anything at that point.
Yeah. I mean, I think the takeaway from that is the 25% tax-free, taking it and giving it away, of course, that's a must. And the other thing, which we must say, is that whatever you do, you've got to do in conjunction with your IFA. And this is very much part of your financial planning. You can't just look at your pension pot in isolation and do what might be really good from a tax perspective, but really lousy from an overall financial planning perspective.
I think also it will be interesting to see how pension companies work in conjunction with lawyers or people who are applying for probate and dealing with the inheritance tax. They would have to pay the portion of inheritance tax directly to HMRC. So I think it will be interesting to see how they.
So the mechanics are going to be quite interesting.
Additional work for the pension companies. Yes. Unfortunately.
Well, as has been widely seen in the press, there's been lots about non-DOMs, and from the 6th of April, so it's about 3 weeks ago, non-DOMs are now in a position where inheritance tax will be levied on their entire worldwide assets, which wasn't the case before in lots of circumstances. If they haven't fled to other jurisdictions and they're still living here, what should they do?
We could do a whole seminar on this. I have done so much advice in the last few months since the budget announcements. A lot of people have been leaving the UK already. Now, there are some transitional rules for those who are already deemed domiciled but not domiciled under standard rules. So people who've been here for more than 15 years but who haven't picked up the domicile under a legal sense, providing you're able to become non-resident in 2025-26 of the current tax year, although you're leaving it a little late now. If you are able to become non-resident, there are transitional rules that mean you will still operate for IHT purposes with a shorter tail. If you are still UK tax resident this year and you've been here for more than 10 years, it could be 10 years after you leave the UK before you fall out the UK IHT net. And that's what the big problem is here. And we're having to look at this on a case-by-case basis, because for people who were born in the UK, these rules are actually slightly more advantageous than the existing rules. But for those people who weren't, who have come to the UK but have made it their home for a long time, it is a lot less beneficial. There are issues with that, but getting a proper advice sooner rather than later to find out whether or not it is right for you to perhaps think about leaving now is still an option. Time's ticking, so you have to be mindful of that, I think.
I think it's important to know the distinction between tax residency and legal residency. Tax residency is based on your actual physical presence in the country throughout the tax year, and legal residency, also known as domicile, is the place where you're most closely connected to, where your permanent home is. It's usually the place where you're born or where your parents are from. So you could be domicile in the UK where your permanent home is, but be resident somewhere else where you're working, for example.
There's also the problem, it's very easy to pick up residency in certain countries, for example, Jersey or Guernsey, but being resident in Jersey or Guernsey, wherever, doesn't mean you're not going to be UK tax resident. Understanding the local rules of how you get out of a country is important. We have a statutory residency test here, And if you've been here a long time, it's quite difficult to lose your UK tax resident status. And just picking up a residency somewhere, I mean, the UAE is the popular one, obviously. Just picking up UAE resident status is not going to make you non-UK tax resident,
But
unfortunately.
there's clearly lots of planning opportunities.
Absolutely.
And there's four-year window.
Absolutely.
Doing lots of stuff. I guess.
There's a 4-year window for those coming to the UK.
Coming in,
There are lots
yeah.
of plans. If you're not already in the UK, we are straying way off IHT at this point. But if you are coming to the UK for the first time, there are some great opportunities, and again, lots of planning that can be done around that.
I think we're taking the view that doing nothing at all really is not a great option, because you're going to have problems coming down the tracks in the very near future. An interesting article in the newspapers, Daily Telegraph. It's possible to divorce your wife and marry your mother-in-law in order to inherit or be given her assets inheritance tax-free. You can then remarry your wife and give her the assets tax-free. Does that work?
It's icky, but from a tax point of view, it can work because of the interspousal release. So, for example, if you are going to marry your mother-in-law and she passes away as her spouse, she can leave you her entire estate tax-free. If you remarry your wife, you can make a gift for IHT-free and CGT-free because it's interspousal. So it does work. But I think you've got to think about a lot more of the legal things around it. One, whether you want to do it, what the costs involved are, and I mean, it's got to be valid. So
Yeah, so this was a landmark case in 2005. A British woman wanted to marry her ex-father-in-law, and it set a precedent in British law, which means that you can now marry a father-in-law or mother-in-law from an ex-spouse for this purpose, which is obviously a bit disturbing.
it's got to be consummated, hasn't it, to be valid?
Yeah, so I mean, that is true. Has to be consummated, to be valid. But also, I mean, would you actually want to do it when you weigh up the costs? You're looking at 2 divorces, which can be costly, and then also 3 marriages, which weddings are expensive too. You've also got your first spouse may make a claim against your estate under the Inheritance Provision Family Independence Act. They are one of the classes of beneficiaries that can make a claim. It can be quite costly. So is it really worth it financially to go through all that? Also, how many of us actually like our mother-in-law and father-in-law? The other thing is that marriage automatically revokes your will. So that's an important point to be aware of if you are getting married soon, thinking about getting married, that you put an in contemplation of marriage clause in your will, or if you've just got married, review your will to make sure that it's not invalid. Saying that, however, the Law Commission has been reviewing the Wills Act since 2023, and actually their report is due in May. They are looking at changes to make to the Wills Act, and one of those changes is changing the automatic revocation of wills by marriage, and that's largely due to the increase of predatory marriages. Yeah, so there are some. So the Wills Act has not been changed for over 150 years. So it's about time that there are some changes, and so things will most likely change in the near future.
Okay, lovely. Thank God. So I'll come on to the question. There's a question that's come through on the chat, so I'll come on to that in a sec. But everyone watching will be getting follow-up emails. Thank you for attending. If anything comes to mind after the webinar, contact us and we'll be absolutely delighted. Aarti, Michaela, one of our colleagues, one of Aarti's colleagues, will be absolutely delighted to help out. Now, just got a question that's come through. Quite complicated one, I'm afraid. Very complicated. Well, with regards to inheritance tax for real estate owning companies, if the companies are UK based, but the shares are held by an Isle of Man company, what would be the treatment by HMRC? UK
real estate,
but Isle of Man company.
Okay, so we're looking at an offshore company, break it down, offshore company owning UK real estate. Now, if that is a property rich company, I think it's 75%. If it's 75% of the value, if that company is made up of UK real estate, and an individual who owns those shares passes away and they have at least 25%, then that is still treated as a UK asset for inheritance tax purposes. So on death, there is inheritance tax to pay. Effectively, if you have got UK real estate, however you own it, whether it's directly or indirectly, there will be inheritance tax to pay somewhere along the line. But if it's an offshore trust, the offshore trust is going to pay tax under the relevant property regime. If it is owned individually somewhere along there, then the individual will, when they pass away, however many layers of companies you've got involved in it, will be paying tax, or the estate will be paying tax on death.
Any legal on the side? No, is it
I
pure
think
tax?
Michaela's covered that.
Sorry, guys.
Okay.
There's no way around it. He used to work, not anymore.
Lovely. So inheritance tax, a huge area, lots of stuff to cover, but we've touched on other areas such as trusts and other taxation areas. Again, please speak to Aarti if things come to mind after today. Thank you for joining us, and please go on the website and you'll see the forthcoming events that are coming up very shortly. Have a great day.
Thank you very much.
Thank you.